At this point in time, I'm going to call upon everyone so we can stand and pledge allegiance to the flag. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd ask that we all remain standing for a moment of silence for our soldiers who are in harm's way in the Middle East, in honor of their service. Thank you. I haven't done it. We'll just make sure we put it up for the record. All right, so I'd like to announce that our next scheduled meeting is on April 6th of next month at 6 o'clock p.m. Here at Town Hall. And that hearing is for the Hathaway project on Hathaway Road, which is another 40B project. We will have another hearing on this matter on April 13th. For this, the Hawthorne 40B project. And that one's going to be at the high school. That one will be at the high school auditorium on April 13th. And the reason for that is there's a conflict because the select board will be meeting here in this room. And the other meeting that we have with the 40B is Sherbrooke Farms, and that will be held on April 30th at 6 o'clock here at Town Hall at room 304. I also would like to announce that this meeting is being recorded by Dartmouth Community Media. And now moving on to the public hearing portion of tonight's meeting, and we only have one matter on this evening, which is comprehensive permit ZCMP 25-1, which was continued from February 12, 2026. The petitioner applicant's Paul Cusson. The owner is Bliss Investors LLC. The subject property is 970 Tucker Road, also known as map 46, lot 2. It's located in the single residence B district, and this matter was legally advertised on August 7th and August 14th of 2025. And we've already waived the reading of the abutters list. In this particular case, the petitioner is seeking a comprehensive permit pursuant to Mass General Law 40B, Section 20 through 30, and the Comprehensive Permit Guideline 760 CMR 56 from the Massachusetts General Laws and Dartmouth zoning bylaws. The petitioner applicant is proposing a development on approximately 56.3 acres to be known as the Residences at Hawthorne, to be located at 970 Tucker Road. The development will have a total of 147 homes, units. I think it's been changed. I think it's 100, where are we at now?
138.
138. We're at 138 units, some of which will be single-family and 30 duplex units, I believe. We'll get, this has changed as this process has moved forward. So they reduced the numbers, and I don't know the actual allocation, but that'll be brought to us, I think, very shortly if we ask the petitioners. I'm not going to read through all the code sections that they're seeking relief from, but just to, we usually start these hearings by giving the petitioner an opportunity to come forward and bring us up to speed as to what's transpired since the last time they were before us.
Okay. Can I
Yes,
also give
absolutely.
the board an update?
Sure.
So tonight, the board is operating under an extension of the deadline to close a public hearing. Currently, that deadline expires tonight. If a further extension is granted, then the meeting on the 13th will be a public hearing. If they do not grant a further extension, the board will still be meeting on, or assuming you vote to do so, on April 13th, but it will be just a discussion of the board with me to go over the conditions and discuss and debate the conditions amongst yourselves. So if the public hearing closes tonight, that means can be no more peer review input, no more applicant input, no more public input after tonight. If it gets extended, then of course, all of those things still apply. So that's the time frame that the board is working under tonight.
Okay. Well, I think what we have to go over tonight is we're gonna have to go over some of the waivers that they're seeking, right, if I'm not
Yep.
mistaken, and also the conditions that we'd be imposing as well.
Right. So what's proposed for tonight is, as you know, from doing prior 40Bs. There's a lot of conditions that may be similar across different projects because they're more general types of conditions, but then there's project-specific conditions that are recommended. And so what is suggested to the board for tonight is to walk through the project-specific conditions that have been recommended or have come out of during the public hearings or that the board may have made note of regarding traffic, civil and stormwater, and water and sewer. I think those are the major topics. And then there were some various other issues, including the emergency assets, et cetera, that have been discussed at public hearings. And I've summarized those for the board in the outline that you have there. So that was going to be the suggested process for tonight, is to walk through all of those. And then at your next meeting on April 13th, at that time, you would have full-blown detail, every condition in advance to be able to read through them all, including the general ones. You have a sense. If that public hearing's still open, the applicant will get a copy in advance. If it's not, they won't. And then, get whatever final feedback from the board. If the hearing closes tonight, the deadline to file the decision will be May 1st. So that's
40 days.
So, it could be discussion tonight of the specific, discussion on the 13th of the entire body of conditions. And then the board does have a meeting on April 30th. The decision could be finalized for that meeting to be voted and signed on the 30th and then filed on the 1st.
I think we have another matter on for the 30th, though.
Right, but if the board was just down to, you will have gotten the final version of the
Yes.
decision, and if you're just down to voting it,
Yes.
it wouldn't take up too much of the board's time on the 30th. So, just trying to work within the meetings you have so that you don't have to try to
Okay.
fit in extra meetings.
So we don't have an actual working draft of all the conditions that we would need to consider in this right now, as we sit here today.
No, tonight, it's just the site-specific related to traffic, civil, stormwater, et cetera. And we can, there's a summary in the memo, and then the letters are here. And we have your civil peer reviewer, Mark Gabriel's here to walk through his letter. DPW Director Tim Barber is here to talk about the water and the sewer. And I was going to summarize the recommended traffic conditions.
Okay. All right. So who do you suggest I call up upon first?
Like Attorney Tallerman would like your attention.
After him.
We can, whichever, do you have a,
Whoever you want to hear from, if you want me to sit and
Fair enough.
wait.
So we'll start to hear from you.
Yeah.
Sure. Bring us up to speed as to what's transpired since the last time you came before us.
Right. So I don't think from our end as that much has transpired. Over on Friday, we saw in the online portal anyway, 2 peer review pieces of information, one from DPW, one from Stantec. And then today, Niche provided one as well. We've taken as much of a look as we can, given the shortness of time. They seem more along the lines of the kind of things that you would put as a requirement for us to take care of in final plans. I didn't see any showstoppers or anything in there. Christian Farland is here to answer questions if there are any technical issues or address those issues. So it looked to me that they all provided kind of a comprehensive set of recommendations that might form the basis of things we have to take care of in that final plan set. So we don't have any new information based on that, and given the shortness of time, obviously we didn't prepare a memo addressing each one of those things. So we're here just to answer questions or to offer comment or work. We haven't seen any draft conditions or anything like that, so we can't comment on that either. We're happy to, but we haven't seen those. We think we've provided all the evidence, unless there's anything that's unforeseen that requires us to go back and sharpen our pencils. We'd suggest a closure of the hearing tonight, but we're open-minded to what happens here tonight. But our position right now would be that we'd close tonight so you all can get at your deliberation when you get back together again.
And I am inclined, but it's just that I think that it would behoove you folks to consider continuing so that we could have the back and forth dialogue to ensure that, these conditions are something that are gonna be, that would work for you, that would work for us, so that we can streamline the process that the next time that we're here, which, I don't know, I guess the next date would probably be the 13th. But let's see how far we get tonight, to
Right,
see how
and,
things
and
go.
and on that issue, and it's always your call as a board, as long as we're not introducing new facts, we could respond to the conditions themselves as to the form of them or the sufficiency. Those aren't new facts, so even after you close the hearing, but that's your call. The board has every right to not share with us a draft during the deliberation phase, but I leave that to you and your counsel, so.
I think I would rather share a draft.
Right, my only concern with, if the hearing is closed and.
Well, then we can't take any input from anyone.
Right, so then, well, if they're here and they're answering questions about the conditions or asking a question about the condition, but then does that mean members of the public would not be able to do the same? So which they wouldn't. So that's if, by doing it the way Mr. Talman suggested, which may be legally appropriate, but it would mean that members of the public would not be able to engage the same way with the board. And so, that's kind of the downside of doing it after, having that conversation after the hearing's closed.
All right.
And like I said, that's your call. It's perfectly legal to do it, but I understand you get to run your meeting the way you like to run your meeting.
As a matter of practice, when we just do regular special permits and variances, when we read in some findings that we're putting together, suggested findings for the board members to consider, and maybe a proposed decision, just for suggestive purposes, we always leave the public hearing open for the very purpose of ensuring that if there's something that, because sometimes we make mistakes, we may refer to the wrong parcel or whatever it may be, that gives the applicant an opportunity to actually step up and say something, or a neighbor that may have a concern about something to step up and say, well, I'm a little concerned about this condition or that, so that maybe we can tweak it that works for you, works for us, so that, we're taking and balancing what we need to do, which is the local concerns versus the need for affordable housing.
And I think that's an excellent practice. It's part of the reason why we had hoped to maybe receive some draft conditions at this point. We haven't.
No,
I mean,
I get that, but.
I've worked on a ton of 40B permits, so I'm happy to dodge and weave.
We are a volunteer board, there's only so much time that we have.
No
And
question.
I dedicated a big chunk of yesterday's rainy afternoon to really go through some of this stuff. We're looking at the waivers and all of that, so.
And I'll speak to my clients too,
Okay.
but that's where we are right now, and I just wanted to be candid about it. But we're here tonight to help answer any questions that you have and go over any of the issues. I've tried to look as best I can, as has Christian, at the peer review. I've kind of looked at some of the stuff on the more legal issues. So I don't think, again, there's any showstoppers here, but obviously we want to be responsive.
Thank you.
Thank you.
All right.
Mr. Chair, if it's okay with the board, what I can do is kind of walk through
Yes.
the outline and then kind of get to the more specific. So basically, without getting into a lot of detail, it's just a basic outline of how the conditions are going to play out in a decision. There's a regulatory conditions that, require the 25% in perpetuity. The board doesn't have to require perpetuity, but as a general rule, boards do, because if you're going to bypass zoning for the purposes of affordable housing, it's usually preferable that those 25% remain affordable in perpetuity. There is a local preference, I'm going to talk about that in a little more detail, that the board can put in a condition in. There's a regulatory agreement that's part of every 40B project. The next part is subdivision conditions. So this is different than the other two 40Bs that the board's reviewing, because this is actually a subdivision of land with new roadways. So the subdivision control law, which is a state statute, and the planning board's rules and regulations come into play, so that there will be a special section that is the submission of everything required under the subdivision control law, since it's a state law. It's not overridden by 40B, so there will need to be a definitive subdivision plan. There will need to be a surety or a guarantee pursuant to the subdivision control law. There's going to be, as we understand it, and this may be questions for the applicant as we go along, it appears that there's going to be both a homeowners association and a condo association for the duplexes, so it might be helpful to understand how those are going to interplay with each other. And then there's the submission of updated, complete plans and project materials, and that's where kind of the technical review is going to come in with Mark Gabriel's here, Tim Barber's here, to kind of go through all of the updates and post-approval submissions, as they've been referred to. And then there's general conditions about prior to construction, during construction, post-construction, et cetera, that will need to be addressed. And then finally, there's the waivers. So that's how the decision is going to lay out. And so the first topic, I don't know, we don't have to go in order. I have here on page 3, but I have roadway, traffic, and circulation first. And I'm happy to just go in order if that
Yes.
is simplest. Okay. So neither of the traffic engineers are here tonight, but I did touch base with Jeff Bandini from Niche, who provided peer review letter for the board. And what you have is the original transportation impact assessment that was done on behalf of the applicant from Vanessa and Associates, and the traffic engineer, Jeffrey Dirk. He, on page 28 through 30, had a number of recommendations. Most of these are being addressed kind of in the other plans, but I'll call out some of them. So for example, we'll talk about the emergency access as a separate conversation. There's a couple of conditions about signage, stop signs, pavement markings, et cetera. Niche Engineering's peer review letter does make recommendations on conditions for those. So those are where a couple of things where the traffic engineers are in agreement. There's reference in here to the need to have a widened sidewalk area at the entrance for a bus stop. Obviously, bus stop was discussed during the hearings as needs to be accommodated. There's also some recommendations here regarding drive aisles, et cetera. On the next page, there's, crosswalks, ADA compliant ramps for sidewalks, et cetera. Appropriate signage, traffic-related signage, and then dealing with snow accumulations to make sure that there is safe sight distances. So those are the recommendations that came from the applicant's traffic engineer. Their discussion, and the board may recall this, about, there's that Route 6 MassDOT potential project, et cetera. In their original, they had no recommendation for anything off-site. We'll talk about that a little more in Niche Engineering's letter. And then there's, this is pretty standard, currently for all projects, is a transportation demand management. It's called a TDM plan. And it's when the applicant puts together a package for every new owner on trying to make available to them information about how to kind of best use either pedestrian, bicycle, or other public transportation options to reduce traffic. So there's a number of those that overlap with the Niche Engineering letter and proposed to include in the specific conditions for this project. The Niche Engineering then kind of dug in a little bit on some of Jeffrey Dirk's. And there's a letter dated January 7th, 2026 from Jeff Bandini. And his first recommendation is on page 3.
Where are you right now?
I'm sorry. So now there's a letter, there should have been in your packet, a letter from Niche Engineering dated January 7th.
January 7th.
I got the March 23rd one.
So that, yeah, there should be one January 7th, and on the right, it'll say Traffic Engineering Services.
Let me go get it. I have them.
Continue on.
Yeah, it was with the one from Jeff Dirk, so hopefully, but I'll just keep going. The first one is a recommendation that the applicant perform a comprehensive review of signs, pavement markings, and locations of roadside objects on Tucker Road between Route 6 and Allen Street, and provide recommendations for roadway safety improvements. And this is something that the applicant had committed to in their responses to niche. This is a kind of traffic safety review that the board could require be done before, it could be done before building permits are issued for the first unit, or at some point before the first C of O, et cetera. But it's basically to identify potential signage, striping, et cetera, in the existing public way, and then work with, DPW to see if any of those safety matters can be implemented in a way to make the travel on the roadway a little clearer and safer for the public.
I'd like to adopt that.
Okay.
So when you're gonna draft these conditions for us, correct?
Yeah, so
And you're gonna list all of the ones that have been addressed by all of the peer reviewers
Yes.
that we've engaged to make the suggestions.
Right.
And then we will review those and see whether or not we think that they're necessary or not necessary, and also get input from the petitioner as to what their concerns would be about those. Because, like, one of the things that comes to mind for me is Tucker Road is a very windy road. Maybe there ought to be bigger or better signage to indicate that there is a curve coming up with better reflective material or whatever that could be to make the road a safer roadway because of the additional burden that may be placed with the traffic that serves this particular premise.
and that's what the purpose of a traffic safety audit is.
Okay, so, but that's only one example of many.
Right.
Okay.
Right.
Fair enough.
If I may,
Yes,
Mr. Chair, I
absolutely.
think all of the.
Gentlemen, just come in whenever,
Right,
anytime.
so whatever concerns or issues they were not addressed so far, I think there's a lot of things that to be done with the future, It would be included with the conditions, as the special conditions.
Yes.
And, right, so, and I think at this hearing, we can probably hear from the petitioner, which they indicated they have no issues. I'm sure they've seen the peer review, they've seen DPW review, and they know what the outstanding issues or concerns that they have to address, right?
Right, for the most.
In fairness to them,
Yep.
they only got this stuff on Friday.
No, I understand.
Okay, fair enough.
Some of them came in, and that's part of the reason why we don't have kind of a whole document with them all fully written out, is that we knew that there was some final comments coming in from peer review, and we wanted to make sure all of that could come in, and so that, the actual conditions can be as complete as possible. Okay. Emergency access comes up again in the niche. We will be talking about that separately. Again, a lot of the recommendations in niche are talking about looking at traffic on Tucker Road and Way. So for example, on page 6 of their letter, there's a recommendation about safety enhancements regarding speed reduction, particularly in the vicinity of Friends Academy. Yep. So that's on page 6 at the bottom.
No numbers on this.
Yeah, it's on the top left. There should be page numbers. So on the bottom,
Yeah.
recommend that the town condition, the applicant implement speed reduction measures and mobility improvements near Friends Academy if necessary. Again, these are all, because it's in the public way, it would have to be in coordination with DPW. But that would also be first identified during a traffic safety audit of these areas, and then, working on the implementation.
continue on, I'm just reading
Okay.
what you had just read. I just wanted to make sure I read it for myself, thank you.
Sure. So the next one is on page 8, the niche follow-up response. And this is one of the ones I spoke to Jeff Bandini about today. So this is talking about doing monitoring for 12 months post-occupancy. He didn't specify in here, so I called him today for clarification. If we do have an extension of the hearing, we can get it from him in writing, but I did confirm with him by phone today that it would be after the first phase, so that get a sense of once traffic is coming in and out of this intersection, it's not really so much the volume as much as the interaction of the cars coming out of the development with traffic on Tucker Road, and get a sense of, what other, again, signage, pedestrian, traffic signal timing, those types of things should happen in order to improve the flow, particularly right at the project entrance. So there's a number, you'll see, this is a response number 6, to item number 6. You'll see as we go through that niche refers back to that response a number of times. The comment on the top of page 9 just has to do with having adequate parking around the kind of the clubhouse main building. At this point, they're saying that there is sufficient parking, and they're just recommending that parking be maintained. And so that if there's going to be changes or reductions in parking, that should be reviewed by the town.
Question, when it says that we recommend the town condition that any modifications to the parking supply be documented and presented to the town for approval. When they say the town for approval, does that mean it's gonna come back before us? Does that mean it's before DPW?
Well, for this project, most of the parking is going to be at each of the individual homes. So earlier in that section, it's mostly talking about around the clubhouse. So I think there's just a concern that it not be reduced so much that there's not enough parking around the clubhouse or near the mail, and then you would have potentially cars parking all over the side streets.
I don't know what it means by town for approval.
So for the most part, so the way 40B works for modifications, if the applicant wishes to modify the plans post-approval, they have to submit a notice to the board, and then the board makes a determination. That determination is done at a meeting, not a hearing, as to whether or not the change is substantial or insubstantial. If it's insubstantial, then, it can just get dealt with at that public meeting or just allowed. So if it's something that's deemed substantial, then they would have to come back in. It would be a public hearing. It would be noticed. So, I think that it would be handled, and I think Jeff's wording is just kind of more a general wording, not necessarily the way you would word it for 40B, but it would be a, determination of
Well, if it said to the
substantial or
board
not.
for approval, I would
Right.
understand that. But when it says the town, I don't know which agency.
Yeah,
it's
because
doing.
it could be the planning director, or it could be
Could be the
DPW.
building inspector, could be DPW.
You get to, we'll propose it in the conditions. Something like that, you might want to, particularly where this is predominantly a subdivision, you might want it to be submitted to the planning director, because he's most familiar with subdivisions.
Okay.
Okay. On page 11, this is the periodic trimming on land control to the applicant. This is mainly to just make sure that the plants, trees, et cetera, are not growing out of control so that it blocks the view for sight distance, et cetera. It's just a safety thing. The next is on pages 13 to 14, and I highlighted a little bit on page 14 because to your point, Mr. Chair, it's talking about the geometry along Tucker Road. And it's talking about the safety mitigation, so that there is a proposed condition. And the issue really here is about trying to identify again the signs, pavements, markings, et cetera, to try to improve information on the road, signage, et cetera, markings for the public traveling on Tucker Road to see if there's some safety, and some safety, I'm sorry, I'm blanking on the word, but some modifications, safety modifications as far as signage, et cetera, that might be helpful. And so that's really, again, you'll see that there's a lot of repeat thoughts throughout this, and it's all about, are there ways to improve just the driver experience on Tucker Road to make it clearer and safer, is really what the gist of most of these are. The one on that same page where it says see response number 6, that has to do with the the monitoring for the 12 months, after 12 months. And then you'll see there it's going to start having a number of repeats. On page 16, this is where it's talking about the MassDOT Route 6 Corridor Improvement Project, because there's potential, depending on the timing of this project, and given that the Route 6 Improved Corridor Project, the timing of this construction may be happening around the same time, depending on when they start. And so there's a recommendation that there be coordination, I would suggest maybe through the police department, because typically the police department will be involved in all of the traffic mitigation, mitigation of dealing with conflicts between roadway constructions and the public trying to get to and from where they need to go. So there's just a recommendation of coordination between construction projects on timing. All right. The next one on 17, again, is a, kind of a looking again at the post-occupancy condition and seeing whether traffic signal timing at Slocum Road and Allen Street should be adjusted. Again, that would be something that would happen after there was already traffic being generated, and seeing what the impact on the traffic signals would be. And that's, again, would have to be coordinated with DPW. On page 18, again, this is part of the 12-month monitoring. So you'll start seeing a number of kind of references back to items that should be monitored moving forward. Same on page 19. On page 20, when it's saying see niche response number 18 a couple of times, that again is coordinating construction schedules between multiple projects that may be happening at the same time within the town. On page 21, at the bottom, there's a kind of a request for painting. You may have seen it in some intersections. I don't know if they have any of these in Dartmouth, but sometimes you'll have intersections where it'll actually be painted, crosshatch, do not block, to try to keep the public from blocking intersections so that you don't end up with gridlock at a four-way. So that's what's recommended here, is again, would have to be approved through or, kind of coordinated through DPW.
I'm hoping that's not going to be necessary.
Yeah, I mean, it's a recommendation to try to help prevent certain conditions from occurring. So it's a little proactive, but it's going to be up to DPW whether or not to allow that. On page 23, again, it's just this selective trimming for safety purposes and for sight distances. And then finally, on page 24, there was a request by the police department that 2 radar speed feedback signs be placed along Tucker Road, north and south of the project, for a period of 6 weeks after occupancy. My recommendation on this is we can check with the police department as to whether they want that after it's fully built out, whether they would want that after phase 1. It's just a matter of timing, because because it's 138 homes and or units, and the applicant indicated they may phase it, so we'll just have to confirm whether or not that should be done after the first phase. There will be, in the kind of general construction conditions, a requirement that they submit, if they're going to do phasing, that they submit a phasing plan. And there'll need to be conditions about which of the infrastructure would need to be completed, with phase one. So for example, often stormwater has to go in at the beginning, regardless of how many houses that you're going to be building. So those are the traffic recommendations at this point. As you can see, for the most part, they have to do with trying to manage and improve to the extent possible just the flow of traffic and safety of traffic along Tucker Road around the project site.
All right,
All right, so,
moving on.
yep. The next is going to be civil stormwater and subdivision, and if it's okay with the board, then Mr. Gabriel can come up and
Absolutely.
walk through his
Mark
letter.
Gabriel, right? Come on up, sir. Bring us up to speed.
Evening, Mark Gabriel, Niche Engineering, Civil Site and Stormwater Peer Reviewer. So you have a letter of recommended conditions from us dated March 23rd, today.
Yes.
In here, it's about 6 pages, about 33 recommended conditions. In a second, you can let me know how you want to go through it, but basically, these conditions pull from our peer review letter and the response from that letter from back in January 7th, where the applicant stated, that, thank you for the comment, we'll address this post-approval. So a lot of those items that were in there are all been, rewritten into this letter as a condition because it was stated it would be done post-approval. What else? There is,
Hi, Mr. Gabriel, if you could just speak a little bit louder for me, please.
sure.
Thank you.
Yep. Through here, or you? And then there is other recommended conditions in here based on discussions as well with the town. And so basically, a lot of these conditions here, you've either seen one way or another, just all written into one neat, clean letter here.
Okay. Can you go over some of them for us?
Yes,
Major
sure.
ones that you feel of most concern.
So it's broken into 3 parts. It starts with Part A, which is just the plan recommendations. These are just high-level parts. Part B is more of civil recommendations, and Part C is more stormwater recommendations. Plan recommendations are more, you'll see those more administrative-type processes, such as, comment A2, or the second one, just submitting for records state and federal permits that the project's required to obtain. Again, we had that in our peer review letter. They stated that they would do that. So more administrative there. So getting to things that are a little bit more, let's see, in regards to subdivision regulations on page 2 of 6, there's, recommendation number 8 and 9 and 10 and so on. They're basically just bringing the plans up to more of a definitive subdivision plan that is following more the administrative procedures that are written in the subdivision regulations. So explicitly talking about those different sections that are called out in each of those comments. All right. When we get beyond those general plan requirements and get into the civil recommendations, I think that this was touched on briefly already. I think it's important, number 18 under Part B, just in regards to soil and erosion and sediment control. This is a large, will be a large active construction site. The applicant has talked about providing construction phasing, both temporary and permanent erosion and sediment control measures. When doing such land disturbance activities, those are important to have in place, and they've talked about providing more information on that. as well as a stormwater pollution prevention plan, which is a federal requirement from the EPA. All right. There is also comment number 19 about additional geotechnical investigations that are recommended regarding doing some test pits and borings in areas of significant cut and fills along the roadway and utility corridors. Again, already talked to with the applicant about doing that in regards to the peer review letter I provided previously. Let's see. Heading into stormwater, staying on the same vein, comment number 26 on page 4, just doing additional test pits within each of the stormwater basins on the project. That is highlighted in here as well. They have done some test pits, but they need to do more. And they're, again, aware of that in their response to us on January 7th. Let's see. The page 5 of 6, basically revisions to the stormwater report and providing design revisions as needed. And this is in regards to their hydrologic and hydraulic analysis, updating their calculations for their catch basins and inlet grade capacity, which was both called out in our previous peer review letter, but also kind of discussed in the town's stormwater regulations. All right, and that's more a comment 29, if I didn't say that already. In regards to comment number 29, we did get into the local stormwater regulations, the Dartmouth regulations, talking about meeting certain sections of those regulations. 29F is an example, a narrative on the thermal requirements of meeting those stormwater regulation sections of 6C5 as written in here. As well as pollutant removal standards in the regulations under 6D1 as another example. Again, written in my previous peer review letter as well. And then heading to the end here, comment number 30 on page 6, talking about the operation and maintenance plan, providing some clarity on the homeowners association and who's doing what, schedules on non-routine maintenance, and estimated cost for this maintenance. And then heading down into comment number 31 about just easements on these parcels. There are stormwater conveyance swales that reside on residential lots, and those should have easements so that they can be maintained properly because they are a component of the drainage system. And just getting to the end, comment number 33 about the stormwater basin that's located adjacent to the North Dartmouth intercepting sewer easement, and just having that pulled outside of the easements. There was conversations on that at past meetings. So there's more than that just here, but that's just some of the highlights.
Okay. All righty.
So the,
Well, actually, the question for Attorney Murphy. In the special conditions or specific conditions, are you going to list every single recommendation that, or are you going to reference the?
I'd rather
The-
list each recommendation.
Okay.
yeah,
Because otherwise it's going back and forth. I
Okay.
tried to do that yesterday, and I was like, I got to give up
right,
on this.
right. And that's why we had asked Mr. Gabriel to put this together.
Okay.
Because there was so much detail. And in addition to just the peer review letters and the responses back and forth, as he mentioned, and if the board wants to look at the waiver list, we can talk about the updated waiver list at the end. There were a number of items that were on the waiver list that you reviewed at the last hearing that all said, they weren't necessarily requests for waivers, they were just said, we'll submit these post-approval. And so what Mr. Gabriel did was, as he mentioned, pull those all out of there and put them in this letter, which then I can now take and put into decision form for the board.
So I don't have a great deal of experience in plan approvals, but obviously, there are a lot of neighbors here with concerns. Neighbors to the north, neighbors to the east, and neighbors to the south. And they're all, I'm sure many of them are concerned about shedding water onto their properties. There's no condition here to that effect. I presume that it's not there, possibly because the plan has been put forth in a manner where any water from this particular site is kept on this property and not necessarily shedding. But I rely on you to give me a further explanation on that. And I'm sure there are going to be a lot of ears that are waiting to hear this from you.
Sure, that's correct, and I feel you've mentioned it too in the past. The state stormwater regulations don't allow for that increase of flow off the property. Their current design shows that they are meeting those requirements on those different watersheds that they have delineated on their property. I don't feel that is needed to be written into the conditions because it is currently meets that, and down the road they are required to meet that per state law.
So based on the way the plans have been presented by the petitioner, they accommodate all the water and do not increase any water shedding onto adjoining properties.
That's what we've seen, yes.
That's what you've seen.
Correct.
And the most recent plan that you've seen was dated when?
Oh, I want to say that was part of the January 7th response to comments.
So obviously, if one of the conditions is that we're approving that particular plan, then that's what they have to adhere to.
Yes, and in addition, there's going to be a condition that requires them to comply with all of the, it goes without saying, but it's standard to include a condition that they comply with all of the state stormwater guidelines. And as Mr. Gabriel said, that does not allow them to have water from their site going onto their neighbor's property.
Okay. Thank you.
You're welcome.
All right.
So the plan, as we just discussed, would be to take Mr. Gabriel's proposed conditions and work them into the traffic, and work them into the decision based on that outline I gave you in the appropriate locations that the topics that they would cover.
That outline you provided us is pretty much a framework of what we're going to be working with going forward.
Yes,
Yeah.
yep.
And that was a great starting point.
Right.
To utilize.
Yep.
Thank you for that.
Okay, so the next is water and sewer, and Mr. Barber is here.
There he is.
And what the board received, so there was a letter from Stantec that was originally received on January 7th. The letter that was just received on Friday that states on March 20th, it's the same letter with a few additions to it. So it supersedes the January 7th letter, you know, there's a lot of background, obviously, of their analysis, but then there's a few sections with their recommendations. And then there's a memo from Mr. Barber himself. That's also March 20th, and I will turn it over to, I don't know if you want to start with, like, just section 2.2.
Good evening, Tim Barber, Public Works Director. So Stantec, so I'd kind of reiterate, I had issued a letter with comments, and some of the comments are from Stantec's previous letter that were also on my letter, just to make sure that we had it in time, because we didn't get this letter from Stantec until Friday, so, but there are identical comments on both letters. So in Stantec's letter, basically, there was some, detailed technical information where on section 2.2, on sheet 2.1, they mentioned some clarity on the drawings, that it was difficult to read some of the information from some of the sewer manhole connections connecting to the intercepting sewer in the easement.
I'm sorry, Mr. Barber, I'll just interrupt you for a second.
Sure.
If the board, there's the letter, the Stantec letter dated March 20th. Mr. Barber's looking at page 4. Yeah, so he's on page 4 of that letter. Okay, I'm sorry. to
Paid
interrupt.
for, sorry,
He's saying
section
that a lot of the
2.2.
comments that he had are in this letter as well, right? And I
Correct.
presume the bullet points that you're going to speak about are the ones that are in your letter.
Yes.
Okay.
Yep.
Which I have your letter here.
And that'll be part of the conditions.
Again, well, obviously, we're not going to be duplicitous, we're just going to extract, the ones that you put in here,
All
along with
of
the ones
them.
from Stan. All of them, there you go.
I'm sorry, does your letter include the new items that were coming from
It does
Stantec?
not. I sent my letter before we received this letter.
Okay,
But,
so-
but some of the comments, like you mentioned, are the same
Yep,
as the
okay.
previous letter. So, most of them are technical, based on infrastructure placement, pipe slopes, for, recommended pipe slopes from different sewer manholes, invert elevations so they meet into the intercepting sewer correctly, matching crowns rather than at the invert location at the bottom of the pipe, so there's no flow disturbance. Also, making sure conforming that, the details and all the materials conform with Department of Public Works specifications. Also, the stormwater basins that do encroach on the existing North Dartmouth sewer, intercepting sewer easement are, moved, the infrastructure is moved out of the easement, and, any encroachment is approved by the DPW, by me, within that sewer easement to make sure that the access is maintained.
But on the plan, if I remember correctly, they had already moved everything away from that easement. Is that not accurate to say?
No.
Not
There's
sure.
been a slight encroachment at one point, but I think that they've
Yeah,
retracted from that,
It's
right?
mostly grading.
Just
yeah,
grading?
yeah.
But it was like a what, 3-to-1 slope that they were putting there?
Correct. Yeah.
Is that something you're in agreement with?
No, if there's not an existing 3-to-1 slope, you don't, say it's an existing, shallower slope, and you now you bring in a 3-to-1 slope, it may prohibit access. So basically, they can't make it any worse than it is. They can keep it the same or improve.
What's the natural slope there now?
It varies.
So the proposed condition is that, because as a matter of law, which is kind of outside of permitting, you can't encroach or interfere with an existing easement. And so, what's being proposed by Mr. Barber is a condition that, to the extent that they want to affect or modify the grades, that it would have to be approved through the DPW director. And I think that would be appropriate because the board does not have the ability to alter, the town's rights in an easement. Like, no, regardless whether it was a 40B, a special permit, variance doesn't matter because it's a legal right that the town holds.
And we met with the applicant's engineer, and they seem amenable to that as well, so.
Okay.
Also, when you ask what the existing slope is, the existing topography isn't 100% accurate on the site. I know there are some inconsistencies, so I think in Nich's letter as well, they noted on that to, to bring in those correct contours and with a topographical field survey. And on the water side, which if we go to,
Right? None of that for them is a showstopper.
Right.
right, I don't think anything here is a showstopper. Recommendations for the water side on section 3.5 in Stantec's report. They were requesting a fire hydrant at the intersection of Tucker Road near the entrance. Additional hydrants on the water main loop within the site. Details on their connections to the water main in Tucker Road. Evaluating measures to improve reliability and fire flow. And there's a recommendation to upgrade a section about 300 feet of water main, existing 8-inch cast iron water main to a 12-inch ductile iron water main to improve the volume and pressure at this site. I think the existing 12-inch ends at the Country Club Boulevard intersection currently.
And so the Stantec's explanation or rationale for why that is needed in connection with this project is, if you look at section 3.5 on page 9, it's the last bullet, there's 2 paragraphs there.
Hold on a second, let me get there. All right.
So it discusses the existing condition, but then the second paragraph talks about I don't know if, Mr. Barr, if you want to speak to that, the second paragraph.
Talking about the hydraulic modeling indicates?
Yeah, I think it's in the second line.
The 100 gallons per minute.
So they ran a hydraulic model for this improvement, and it resulted in a significant improvement in available fire flow capacity throughout the development. In the fire flow availability chart on the previous page, there was one road B dead end, which had a below 1,000 gallon per minute available fire flow at 20 psi. So this would improve that. And additionally, the peak flows and demands that were calculated for this development were based on the development of the residential dwellings and the clubhouse, and didn't include any additional demands, which could be during peak times for like irrigation. So that would further, decrease the volume and pressure availability, where the additional 12-inch main would prevent increase that capacity and volume. So other technical requested information for detailed water main utility design callouts for all their infrastructure. Confirmation on water main piping, services, valves, hydrants on the plans, fire flow requirements, written confirmation from the fire department for hydrant spacing, for fire hydrant spacing. And then the last item confirms the demand, including any possible irrigation. So then that pretty much ends the recommendations for Stantec's letter. If we go to my memo. So, speak on some of the technical aspects, including the access easements. So we request that supply an access easement to the town to the North Dartmouth intersecting sewer easement for additional maintenance and repair access through the site. Once it's developed, there'll be ample ways to access the easement through their site.
Have you spoken to the applicant's engineer about that?
I have, yeah.
And what was his position?
They were amenable to it. We haven't seen anything on the plans or in response in writing yet, so.
May I ask a question, Mr. Chair? So I don't want to put Attorney Tellerman on the spot, but given that it would involve, so given the layout of the design, I don't know if you're aware of this issue, because of the North Dartmouth intercepting sewer easement runs across the back of the site. That's what they were just talking about, changes of grade for the drainage basins, et cetera. But with the layout of all the houses, it's going to affect the town's ability to access that easement, and Mr. Farland's aware, we spoke at some other, but because would be the applicant or the owner granting an easement to the town, which doesn't currently exist, if the applicant or the owner is amenable to that, it would be helpful to get that on the record, because obviously it's not a condition the board can just impose that the owner grant an easement, so.
Yeah, I mean, subject to physical, possibility, as long as it can be done. We are no objection to a condition that says any necessary easements for infrastructure utilities, whether it's DPW or public safety or anything, making that a condition and also making those easements subject to town councils or special council's approval. I mean, that's pretty standard fare. I mean, we would expect that. If there's a necessity for the town to get somewhere on this site, or even in a pinch, or even have that reflected in any of our association documents, that's all standard fare. We'd be perfectly accepting of that.
I appreciate that, but you understand, like, the board couldn't just start demanding
Yeah, I mean,
easements, and
these are
so
the
we'd like
kinds of
it.
things that
We just
you-
wanted to get it confirmed on the record, so we
Yeah.
appreciate your comments.
Yeah, these are the
Yeah.
kinds of things that you and I both do all the time, and
Right.
kind of grit our teeth a little bit, making sure it's okay, because you can't like impose those things unilaterally. But the project, if it's necessary for the project, of course we would. Yeah.
Thank you.
Additionally, same with any of the stormwater easements to access and maintain the operation of any of the stormwater basins and swales. And I think, Mr. Gabriel also spoke about that, and we did speak about that with the applicant's engineer, and they also seemed amenable to that. Just another thing, any existing utilities that are on site currently, everything should be shown on the existing conditions plan. And then any existing utilities that are planned to be abandoned will need to be abandoned back to the main and per Department of Public Works specifications, and those should be also shown on the plan to, where they plan to abandon those.
Is that current building now tied into town sewer?
I believe so, yeah. Yes, and water, yeah.
Water.
And I believe fire supply as well. All right, let's see, on the second page. Same thing, I talk about confirming to subdivision standards for utility locations, like water main locations, specific locations, whether on the west side or the north side, depending on how the roads are running, that conforms with subdivision for consistency. Is confirming that all utility construction conforms with Department of Public Works specifications, rules and regulations of the installation and connection of building sewers, and for the rules and policies of the Water Division. And that all proposed utility plans shall be submitted for approval through the Department of Public Works. All connection fees and inspection fees shall be either paid for or agreed upon before any construction of utilities. And lastly, we do request additional funding for mitigation in II, as this is a large development. It'll be a concentrated sewer flow that's not expected from this area, which does impact treatment, both flows and treatment for the wastewater. So just, we look at any additional funding that we can acquire towards some of these projects.
All right. I pretty much
As
touched
our-
on both letters.
Yeah.
Sewer and water, yeah.
The sewer and
the
water.
sewer and
What's the next
water.
one?
Sewer and water.
Before, I think we're probably, I think before, I would recommend maybe just going to the next section and saving the waivers for last, if that's okay with the board. Yeah. So in the next section, what I did, and I reviewed them also with the planning director, Mr. Giosa,
Thank you, Mr. Barber.
went through the notes and minutes from the hearings to date, just to call out specific items that were either questions asked by the board or questions asked for the public, and kind of touch, and some of them may have been touched upon already because of how, extensive the review was by all of your experts. But the first one was, and this came up at the first hearing, was whether or not there would be local preference. The board can require that the applicant apply for local preference for up to 70% of the affordable units. At the end of the day, the state agency, Executive Office of Housing and Livable Communities, has to review that application and approve the local preference and also the percentage of units that could be local preference. But it is something that's important to a lot of communities, so that if affordable housing opportunities are created, that it does, to a large degree, benefit people with ties to the community. I did include for the board the 4 bullet points that are in the state policy regarding local preferences. So obviously, it's current residents of the town, municipal employees, so anyone who works at town hall, police, fire, school teachers, et cetera, employees of local businesses that are located in Dartmouth, or households that have children attending. So for example, if there were any Metco students from Boston who live here, their families would have an opportunity to go into the lottery for the local preference units. So this was something that the board had asked about. So I will include a condition regarding local preference if the board would like that. Okay. Okay. So the next one is the emergency egress, which has gotten a lot of conversation at, I think, almost every one of the hearings. As you know, the current plans show an emergency access drive that would be built and come out onto Fairway Drive. The applicant has submitted kind of attorney's opinion with deeds, et cetera, plans, and putting forth their position that the title shows a reservation of a right to access Fairway Drive. The abutters also have counsel who has submitted to the board, I think 1 or 2 letters and also deeds, relatives in some cases, the same deeds, but with a different interpretation of whether or not those rights were actually properly reserved. You know, this is where the 40B aspects of this play in. So there is law that if this was just a subdivision and this was in front of the planning board, the planning board could require that there be kind of definitive confirmation of what those rights are. There's case law to that effect. However, in the 40B context, goes into whether the applicant controls the site or controls easements needed for access or utilities, et cetera. That all falls under what is known as site control. Under the 40B regulations, site control has to be determined by the applicant to the subsidizing agency who issues the project eligibility letter. In this case, Mass Housing Finance Agency, known as Mass Housing, is a subsidizing agency. Now, they may, and I assume just from reading the site eligibility letter, the application for site eligibility, there wasn't really a discussion of whether or not there was access to Fairway Drive or whether or not Fairway Drive was a private way that or not. So, but there are 40B cases that state that if a third party challenges, not the board, but a third party challenges whether or not an applicant has site control over any aspect of the site, whether it's where they're building the houses, where they're putting their utilities, where they're putting their emergency access, that those third parties have to exercise their legal rights separate and apart from the permitting process. So, as I've mentioned at an earlier hearing, I did have a similar situation come up in a 40B project in another community, and it was handled through the courts, separate from parallel tracks with the permitting. And what the board did there is what I'm recommending to the board here, which is that the board acknowledge in the decision and a condition that this is what's proposed on the plans, this is what the applicant has asserted. However, abutters to the property have, also made, arguments that the access is not there, And that the bottom line is, there must be, because it's a fire department, the fire chief has said it's necessary, there must be emergency secondary access. In the event it is determined by the applicant or by a court of competent jurisdiction that that access to Fairway Drive does not exist, then they will have to come back to the board with an alternate design that addresses it. And so that's my recommendation to the board.
Okay. I'm sure at some point we're going to hear some comments from the people
Yep.
that line, but we can go through the rest of
Okay.
it, and I'm sure that that's one of contention.
Okay.
Let me just ask a question. This contention that we have right now about emergency access or egress, that's nothing we can do anything about, other than put something into the decision that somebody has to look at it.
Well, that it's required. That it's
Right.
required, right?
If we require it, then someone has to look at it in a court of law, not us. The town doesn't do it. The local people have to decide whether they want to do something about it.
And that is because of the Chapter 40B decisions, including the Appeals Court of Massachusetts
Okay.
has issued decisions to that
So,
effect.
The people who are complaining about access, the emergency access, it's their responsibility to do something about it.
Under Chapter 40B, that is what the current law is in Massachusetts.
Okay, and I read that case, and I agree with
And
you.
there's a case supporting that as well.
Correct, I read it. I read that case.
Okay. Okay, phases, as we mentioned, the applicant had mentioned they plan to do this in phases. Can I ask Mr. Farland, is that probably the case, that the project would be done in phases? Yes. Yes, okay. So there would be a condition regarding, a phasing plans, et cetera. Already mentioned the homeowners association and the duplex condominium. Mr. Chair, you want to wait till the very end, or maybe the applicant can speak to, would it be helpful in crafting the conditions to understand how they plan on managing the duplexes versus the subdivision?
Maybe we should hear from them as to what it is that they want to do. Counsel? Oh,
Good evening, Mr. Chairman. For the record, Christian Fallon, Principal Engineer and President of Fallon Corp. The duplex development itself is almost its own little entity. So there will be an overall HOA for the entire development, and then within that little duplex area, they'll have their own little separate HOA. Because in that area, there's a lot more easements going on. So that, we envision that as being one larger parcel, versus each individual lot for a single family will have. So there will be basically two. And those documents the attorneys will draft up prior to any building permits being pulled.
So I have a question. So then would the condominium parcel, that association or condominium association, be then a member of the bigger association? Is that how it would be
Exactly.
structured? Almost like a
Yep.
Okay, all right. I didn't really understand how those were playing until I was looking at it last week, so I appreciate the clarification.
No
Okay,
problem.
Thanks. Okay, the site eligibility letter recommendations included a requirement regarding landscape plans for additional screening towards existing homes. I believe that kind of a full landscape plan is one of the plans that will be submitted post-approval. There's the, and I'm losing my sense of direction. So I know on the two ends, on either side, right? If you're on Tucker Road facing it, left and right? There's Fairway Drive, and then there's the smaller condominium right there along Fairway Drive, and then there's some homes on the other side. So just as far, the site eligibility letter had talked about screening for those neighbors. Also, there was a request at the first hearing to get a breakdown of all the individual lot sizes. That, in fact, is a requirement under the subdivision rules and regulations, and I believe it's on Mr. Gabriel's list, that once the definitive subdivision plan is done, they will know every single lot and the square footage of every single lot, and there should be a chart or of some sort that will
But who's
break
gonna-
that down.
Who's going to ultimately approve this? Are we going to put this upon the planning director?
No, so the definitive subdivision plan will come back to the board.
Okay. So it'll come back to us after we've already granted the,
Yeah, so this will be somewhere down the road because they still have to go to Conservation Commission, do their additional testing, that Mr. Gabriel talked about. So I think, after they
so
finalize
let's
their
assume for the
design.
moment that we don't feel, just hypothetical, we don't feel that the screening is sufficient. And that plan comes before us and we have some concerns about that, we can speak to the applicant. But if there's a stalemate between us and the applicant, we've already granted the permit at that point, but there hasn't been a definitive plan that was finally approved by us.
So that's why I have to think about the wording of that condition, and it would probably be helpful. Oh, Mr. Farland can speak to it. Thank you, Mr. Farland, better than me.
There is a landscaping plan that we have proposed. So if there's any comments in regards to that landscaping plan, we provided full screening along the entire property boundary. Those are Leland cypress, spaced every 10 feet apart.
Along the south side and the
Along-
east side?
Along every side that has residential abutters along it. And the plans, you have the plan. So if there's anything different, I would be glad to go over it, but there is a plan of record, is my point I wanted to tell you. This isn't something that would be post.
Okay, thank you.
The things that would be post would be maybe a beautified landscaping plan around the community building. Those details haven't been finalized yet, but as far as screening goes, you have everything.
All right, I'll take another look at that.
Mr. Gabriel could also speak to it if you'd like.
Sure.
Yeah, so just back to my letter, if you still have it in front of you on page 3 of 6, number 17, is just regards revising the plans and details to meet the landscape requirements of the subdivision regulations, section 3.307, except where the waiver for a grass strip is requested. Revise the plans to include detailed landscape design for parcel A, the amenities location that he just mentioned, lot 64, the duplex buildings, and the roundabout, and then we talk about snow storage in there as well. So in regards to if the landscaping, what do you have to say that this landscaping meets your needs? It's written in the subdivision regulations for you there.
And does it meet 3.307?
No, that's why it's a recommended condition that they need to update the landscaping plan to meet those requirements. And
Okay, school bus.
Thank you.
Oh, sorry. The school bus stop, the recommended condition is going to be that they work with the school department and DPW to determine a safe location for a bus stop. We already went through all the traffic recommendations. And then the site eligibility letter, these are all notes from the 9/25/25 hearing, was just, again, traffic, water and sewer capacity, landscape. We've touched about on all of those tonight. And then the traffic impact. So again, a lot of so the 9/25 hearing was the hearing where you talked about traffic, so a lot of those were already discussed tonight. The next hearings were 10/23 and 12/4. There was the discussion about requiring that the roadways remain private. And the homeowner association, I had a question here, discuss this. And then this is a question I have, and I don't know if Mr. Farland, Mr. Gabriel can help out, is whether or not the street roadway that is serving the duplex, is that a subdivision road, or is that a driveway to the condominium? I don't know, Mr. Farland, if that's been determined yet. It was laid out differently. It doesn't have like the full layout the way the other roadways do, so we weren't sure if it was a full layout like a subdivision road, or it's just a driveway off of the new subdivision road into the,
Yeah, it was
Kind of.
designed as a full.
it's
full
not,
layout.
okay, it's more like a driveway into
Oh,
that.
it's a full design, same width as the entire roadway.
Oh, okay, so it would be part of the subdivision
Would
road?
be part of the private roadway.
Okay,
Maybe, are you talking about the portion of any roadway that goes into the condo area, or?
Yes, that's what I'm talking about.
Right, so, and I think that, I just want to make sure, because it can be kind of apples and oranges
Right,
on this.
right.
So we're not looking for, I've always been a little wary about saying all roads should ever be private, because these folks could be citizens and could petition for a layout, whatever, I don't want to prevent that. But certainly, if it's a condo thing that is not, you know, individual lots, I think that would be a driveway. It might still be required by this board for us to meet the construction standards there, but, you know, I would never say that that's part of a subdivision road that could get accepted. So to the extent, and I would fully expect, and, you know, it's intended that these roads be private. And obviously, because there's certain waivers with respect to the roadways, they may never get accepted anyway. But to the extent that it was presented to the select board or to town meeting for acceptance, if I were town council, or you, if you were town council, will say, well, I can't do a driveway as part of the roadway.
Right.
So the things that are along the subdivision roadway forming that basis, those are roadways. Whether
Okay.
they're accepted or not, I don't know.
Okay.
The things that go into the condo are going to be considered driveways. Even
Okay.
if they, regardless of how they're constructed legally, they're not roadways, they're driveways. We would expect that you'd require the same standards of construction across the whole development. But if you're preparing a condition that talks about the future of these roadways, I certainly wouldn't mind you saying like, well, there's all this stuff over here where there's individual lots, but in this condo area, that's, if you want to characterize that as a driveway, that's fine.
Yep, okay, that's helpful. Mr. Chair, is that,
There's mud on that, yes.
is that clear?
I gotta look at the plan again and see what
Yeah.
we're really dealing with. It's kind of, I haven't looked at the plan lately.
Yep, okay. Snow storage, to be shown on the plans, Mr. Gabriel mentioned that. Conservation Commission approval obviously will be needed. There was discussion at these hearings in October and December about the need to secure any detention basins, potentially with fences, to the extent that there's any drops or safety for children in the development. We already talked about the need to comply with applicable subdivision control law provisions. And then on the next page, the stormwater was discussed at length in January. Mr. Gabriel spoke to that today. Retaining walls were discussed, and it was the same issue, that if there are going to be walls that are drop-offs as opposed to raised, like any wall, and I'm not sure, I know we talked about this back in January, I have to recheck my notes. Any of the retaining walls that might involve a drop-off where a child or someone could go off the side might need, would require fencing. Water and sewer we discussed, the sewer easement was discussed. So the next thing we can go through is the waivers. Do you want to do that first? I didn't know if and then we can see if there were any other conditions that the board members felt hadn't been touched upon, and then, but want to talk about the waivers?
I'm sure there are some people that would like to, they've probably got some comments. I'd like to give them an opportunity to state that.
You want to do that before, you want to do the
I'd like
waivers
to do that
first?
before What is it? How long do you think the waivers are gonna be?
I think it'll only take us like 10
Minutes? All right. Because most of them, they've already agreed.
Yeah, it's already been addressed. We're just going to talk about what's
I know it's
changed.
been dwindling over time.
Yes.
How many are left that are still at issue?
Well, there were a couple that had questions, but currently the number of waivers that are being requested, and this is not including, let's see, I'm going to take out a few for headings, would reduce the number. I'd say we're probably at around 53, somewhere around that.
That's what we have now.
Yep.
We went
And-
from 110, went from 110 to 53.
They eliminated some of the.
And at this point, I believe that there is only a couple that were left. So what you have two charts, the board received two charts. The first one is one Mr. Farland provided.
Yep.
So this is the multicolored one. And so what this is showing, and he provided the color codes up at the top, the blue, anything that's blue or change to, anything that's blue or purple is a post-approval submission. So, and these were the ones that Mr. Gabriel mentioned. He went through this list, lifted all of these, and submitted this letter. So if anything's blue or purple, it's not a waiver request. And anything that's in red is, they're removing that request. So they're reducing their requests for waivers. So that leaves you with really the green and the yellow. So anything that's green is, anything that's green is an existing, and then there was a couple of questions left on the yellow, which is the yellow ones were the ones we were gonna go over tonight. So basically, if you take Mr. Farland's chart, what I did was, I took anything that was a post-approval submission, I took it out. And then anything that was red, where he said we're no longer asking for a waiver, those were taken out. And then that reduces it down to this chart that you have.
Good.
So that pretty much cut the list in half of waivers. And so what we're down to, and there may be some questions for Mr. Farland here, let's see, 1, 2, I think there's only three, I think there may only be 3 questions left.
Well, 22 you already addressed.
Right. Well, so, yes, that one we just addressed. That was the question about the difference between the roads and the duplex and the single-family homes. So now that we have kind of the answer for that, then I can go and talk to, Mr. Giosa couldn't be here tonight because he has a planning board meeting happening simultaneously, but I can go back and ask him about that one. The one I think that might be, you might want to discuss with the, Mr. Farland is this issue of having, so you have the right-of-way, and usually the center line goes down the middle. What this regulation provides is that if you have a sidewalk on, right, you have a 40-foot right-of-way, 22-foot roadway, if you have a sidewalk, then the right-of-way is going to shift, right, to the side. There'll be an offset to put the sidewalk in. Typically, or the regulations require that there be a space between the roadway and the sidewalk, right? So it's kind of a safety if a car jumps the curb, someone's not right there on the sidewalk. They're proposing to put the sidewalk right up against the berm and then put, say, a green space and tree over here. And that was a question that Mr. Giosa had as to why are they not putting the green strip between the sidewalk and the roadway for safety purposes? And I don't know if Mr. Farland could, Dan would have been here tonight, but he has his own meeting.
We have no problem with doing a green, basically you got your pavement, it's 22 feet, so it leaves 18 feet. So you got 9 feet on each side. So right now we have the 5-foot strip of the walkway and then a 4-foot grass strip. We can flop it so you have
4 foot? Okay.
3 foot, then 5 feet, and then an extra foot.
So,
We would have no problem doing that. That's,
okay, so a 3-foot green strip, is that what you?
3 foot would be
Okay.
good. It leaves a foot room.
Sorry, Mr. Cello, what, did you?
You said 4 or 3? I mean,
Well, you got 9 feet left over.
Right? So 5 and 4?
So the issue you run into is then you have the street trees, right? So street trees, ideally, we would want to put those, the planning board regulations may have them somewhere else, but ideally, we kind of want to put those almost right along the front property line. Because we don't want them too close to the sidewalk, otherwise the roots are going to rip up the sidewalks. And we don't want to put it within that 3-foot strip because, again, the roots are going to, it's not enough room.
Okay,
So
so,
as long as and I can talk to Dan about this, we have no problem putting the street trees within the property. We can have a street tree easement. We've done that plenty of times.
Okay.
It just makes the most sense to do that.
So it would be 20-foot, 22-foot wide street, 3-foot green strip. Sidewalk is 5 foot?
We have 5-foot sidewalks on there, yep.
And then you'll put the street trees and a street tree easement or something like that?
Yep.
Okay, all right, that's helpful. There was a, I'm just going to go, you'll see that there's some, these were the questions. There were a couple of changes that are in blue here. There was a request to allow 4-way intersections. The recommendation, when I was speaking, so again, when I make these recommendations, they're not coming from me, these are coming from Mr. Giosa. So
Where are you right now?
I'm in line 20.
Okay.
There was a request to allow 4-way intersection. There was that provision is in order to make sure that there's proper sight distances. So the recommendation is to grant that waiver, provided that minimum sight distance standards are met at all the intersections. So Mr. Farland is nodding. Okay, on the next one is line 30. There's a proposal to have a sidewalk only on one side inside the duplex area. And Mr. Giosa's recommendation was that would be okay, because that's a small, kind of isolated area. So a sidewalk on one side in the duplex. All right. On line 44, the first correction to the section name. So in the final, this is minimum lot area. So right now, I have the plan somewhere, but there is a, the first sheet of the plan set has minimum lot size, and I think it's somewhere around 7,300 square feet, more or less, right? But it's not defined. So Mr. Giosa was proposing that it be that no house lot be less than 7,000 square feet, and we just want, is that acceptable? Yeah, okay. And then that same dimensional chart says, has a minimum frontage of 50 feet. Mr. Giosa is fine with that. We're just suggesting that it be specific in the grant of the waiver.
Where are you looking now?
I'm on line 45. Okay. So the next one is line 47, and this probably should have been yellow. So there's number retaining walls, and so I think the comment from Mr. Farland was that the retaining walls are probably going, where there's going to be easements to deal with them if they cross property lines between lots. I think the question that Mr. Giosa had is, if there's retaining walls near a structure, like near a house or near an abutter property line, that there should be some setback of the wall from an abutter, like a off-site boundary line, or from a house, so that you don't have a house placed kind of too close to. And so but again, not knowing exactly where the retaining walls are going to go, I don't know if there's, some minimum setback for it to have, so that a house or a neighbor is not too close to a wall. I don't know if you can.
Yeah, so I think with the slope of the topography of this land, some of the retaining walls may have to go perpendicular to the property lines of the new lots.
Okay,
So we didn't want to have any setbacks from property lines, obviously,
right.
for that reason. In regards to the abutting properties, there's been many projects in the town of Dartmouth where I've done proposed retaining walls right along the property line. And if it's needed, as long as we have enough room to construct it, I don't think there should be, the zoning board should put any restrictions on that.
Could I ask you a question? Would they be looking at the wall, or the wall would be on the other side and it would?
Yeah.
Oh,
if
okay,
anything,
so it's not as if-
It would be the opposite.
Okay, so it's not as if this is my house and now I'm looking at an 8-foot retaining wall.
Exactly.
It would be a drop off, so there would be a fence or something. Okay.
Correct.
Mr. Farland, if my memory serves it correctly, the only area in which there were retaining walls was on the north side of the property. Is that correct, or is there
Along the
somewhere else?
abutting property
On the north side?
on the north side, correct. And
In the east.
technically, it wasn't the abutting property because the town has a
It's
50-foot strip
an
there.
entire easement that sort of serves as the buffer there between
50. Yeah,
the people with homes and where this property is located.
correct.
So if there were going to be retaining walls installed, they'd actually be abutting town property and not neighbors.
Correct.
Okay. Is that all right?
Yeah,
Yeah,
okay.
just wanted to understand that one, so that,
Unless
Right.
they're somewhere else. Please let me know, because this is off recollection. If there are retaining walls somewhere else, then obviously it's more concern. They're not?
East side, I thought?
Not along the property line, no.
Just on the north?
okay. All right. Those were, that was a summary of how the waiver list has changed and the few open items from, that is,
Nothing to be concerned about?
you know what, I think that might be one that got changed. So we're, just
9.
ask a question about number 9. Wait, it was a different number on this one. Section 11, stormwater regs, stormwater regs, number 11, hold on a second. Oh, actually, that was removed, so that should come out.
All right, does that finish off the waivers?
That does.
All right, I need to take a quick recess, a short recess, and we'll come back on the record. The zoning board is back in session, and we're back on the record. So at this point in time, I'm going to open up the matter for public comment. So obviously, I'm sure that some people have some concerns. I'd ask that if the concerns have already been addressed at prior meetings, that they not be raised unless we haven't brought them up in tonight, because we are going to take most of what we discussed here today is in preparation of putting together the actual permit that would be granted to the applicant with stated conditions. And I think there's going to be hundreds of conditions that are going to be imposed on this project. It's going to be quite voluminous. That lady on the end there is going to have a lot of work to do over the next few weeks. But I think most of the conditions that we've spoken about tonight, most of them address a lot of the concerns that the abutters and the people in our community have raised about the project. So if there's anyone out in the audience tonight that would like to come forward, I know that Attorney Perry was here earlier. Oh, he left, okay. If there's anyone in the audience that would like to come forward and address any concerns, come on up. As usual, address the comments to me. You can identify yourself by name and address.
My name is Chuck Rezovic. I live at 4/8 Green Drive, and I'm on the board of directors of the Mill Valley Farms HOA, which is the smallest little HOA down there at the bottom of Fairway Drive. I just would like, I'm not sure I fully understand what the process would be. If you folks go ahead and approve the subdivision, and then we would have the residents on and off Fairway Drive would be required to then go to court, and we would bring the case to court to try to stop access to Fairway Drive as the emergency means of egress. Is that correct?
That's correct, sir.
Okay, that's all I wanted clarified. Thank you very much.
Thank you. Come on up.
Good evening, Mr. Chairman, members of the board. My name is Robert Almy. I live at 307 Smith Neck Road. I'm here tonight as a member of the public. I have degrees in geology, training at the U.S. Geological Survey National Training Center in water, groundwater, and groundwater surface water. 50 years experience in land use planning and water resources. And in addition, I taught environmental impact assessment at the University of California while I held a full-time job. I've seen a lot of project applications. 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 I've seen a I have reviewed most of the application materials on your website. And I've reviewed most of the comments of the town and your residents. My biggest concern with the application is the lack of information provided to the town throughout this process. I got to tell you, I'm disappointed in the applicant's team. They put entirely too much work on the town and the town's professional staff, and have taken that professional staff away from other necessary project responsibilities. Let me give you an example. The stormwater runoff calculations indicate that there will be, quote, greater than 75% of grass on 51 acres. Okay, that's 39 acres, or 38 acres of turf. My experience indicates water demand estimates provided by the applicant show indoor water use of approximately 50,000 gallons a day. Only indoor use is provided. No estimate is provided for irrigation use. Typical recommended water application for turf is 1 inch of applied water per week. This would result in 147,000 gallons per day if the irrigation demand was spread evenly throughout the week. This is nearly 3 times the estimated water demand for the project. Because this overall demand is woefully underestimated, so is the estimated pressure drop in the system, and so is the connection to the town system. One other thing, outdoor water use would occur mostly during the summer when the town's other supplies are reduced and we, water users in the town, pay for more expensive water from New Bedford. All of the existing water users would pay for the incremental increase of cost for bringing in more water from New Bedford. And I point out that the differential in cost is roughly 10 times between the water that the town produces and the water it purchases from New Bedford. It seems only fair that the public should be made of these increased costs, even if the ZBA and the town can't do anything about it. Thank you for your time.
Thank you. Is there anyone else that would like to come on up?
Just really quick.
Name and
Can
address,
you,
please.
I'm sorry, Roy Bertolotto, One Country Club Boulevard. Can you quickly just explain to us what happens if you deny the applicant? What's the next step? I mean, I've heard all kinds of things. I've heard your hands are tied, you deny it, all kinds of things, go to court. Can you just quickly explain that to
I
us?
could provide you an
Thank you.
explanation, but I'm going to defer. No, I want you to stand there. I want to defer to this lady here at the end. She will tell you what would happen if we deny this application. And I have considered that, sir, believe me when I tell you.
Okay, so under Chapter 40B and the regulations that were adopted by the state agency, Executive Office of Housing and Livable Communities, this is how the process works. If an application is denied, then the applicant presumably would appeal that. Their appeal would go first to a state judicial review. It's kind of a judicial review board. It's not a court. It's called the Housing Appeals Commission. And it's a 3-member commission. And they have, in effect, what looks like a mini trial. But then they have all of the experts that you saw on both sides, the applicant, the board's peer reviewers, would all submit their testimony. And the board would, state its reasons why it denied it. And as the chair has stated, a number of these meetings, and he's talked about, there's a balancing act between the local concerns and the need for affordable housing. And the Housing Appeals Committee would listen to all of the town's experts, kind of defend the reasons why the board feels that the application, that the local concerns, whatever it may be, and the board obviously has not made its decision yet, but say it's traffic, or it's the water, or the sewer, or stormwater, whatever the topic is, lay out their reasons why they think that local concern outweighs the need for affordable housing. And then this 3-member panel will decide who they credit, whose testimony they believe to give more weight to. If they were to decide that the applicant has made the case that the need for affordable housing outweighs the local concerns, and that what they're proposing would mitigate all of these concerns that the board raises in its denial, then the Housing Appeals Committee has the authority to issue the decision, kind of bypass the board, issue the decision, impose whatever pre-written boilerplate conditions that the Housing Appeals Committee attaches to any permit that they issue, and those would be the only conditions that the project would be subject to. Now, the town could try to appeal that to the land court and the appeals court and even the SJC, but ultimately, if the town does not prevail, then the project goes ahead and it doesn't have the 25 pages of conditions that the board might impose. It has maybe 1 page of conditions that the Housing Appeals Committee imposes. So that is the risk to the board, to the town, if the board denied the permit. Now, it's not for me to say, I'm not the board, whether or not there's any facts in this 40B application or any of the other 40B applications before it that leads the board to feel strongly that it has the evidence from its experts that there is a local concern that cannot be overcome by imposing good conditions on the project. That's the board's job. But, that's the possible outcome of what could happen.
Thank you. I will start from the left, then I'll work my way over to the right.
Robert Saltzman, 966 Tucker Road. Mr. Chairman, can I just continue with the attorney? Then what happens if the board approves it but attaches the 25 pages of conditions?
Okay?
I didn't understand the question, sir. Did you understand the question?
No, the attorney had said, what would happen if you said no, but she said if you approved it, and she said there were 25 pages of conditions.
Well, that was just a number that she put up there.
I get that. I'm
Yeah.
saying, but I'm asking for the next alternative, if you approve it with a lot of conditions.
That's correct.
What can happen?
That the applicant doesn't like, but you have approved it conditionally.
Okay.
What happens?
All right, well, either the applicant, even if they don't love all the conditions, will say, we would like to move forward with this project and not have further delay, and they'll work with the town and they'll move forward with the project and comply with the conditions, so that's option A. Option B is they could appeal to the same Housing Appeals Committee, and they could claim that a condition renders the project, it's all terms that are defined in the regulations, so I don't want to get too legalistic on you, everybody, but there's a term that it would render the project uneconomic. So that's one thing they can claim, well, these conditions make this project so expensive, it's uneconomic for us to build it, so therefore the conditions go too far. Or they could claim conditions are outside the purview of the board and therefore are not appropriate. So they could challenge them from their various different aspects. And then the same little mini trial would happen where the experts would provide the evidence and the Housing Appeals Commission would decide which way it would go. And I just finished a long litigation over 40B in another community the Housing Appeals Committee upheld some of the board's conditions and said, you know, developer, we don't agree with you, we're going to keep those in place. And then they disagreed with the board on some, and they threw some of the conditions out. But, you know, there was that same balancing of the local concerns and the need for affordable housing and what the actual impact might be on the developer. And then at the end, the permit, there's a final permit. So that's what that process is.
Ma'am, I think you're next.
Hi. Nancy Thibodeau, 8 Country Club Boulevard. I have a couple of questions. One that you were just saying about this litigation and all that stuff. If they throw out some of the important things that you've put as, you know, has to be done on these projects, if they... Conditions. If
They have to follow them. If we put them there, they have to follow them or they appeal them.
Right. But if that
Commission.
little
He's saying
trial that she's
HAC,
talking
if the
about, the
commission-
appealed trial thing that she's
Oh,
talking
okay,
about,
yes.
if you go up to them and then they get rid of it and stuff like that, and those things cause a problem where you people had already decided that that should have been part of the project, can't we go after these people, the state or whatever, whoever, you know, said it was okay, and make them pay for the wrongdoing on it? I mean, somebody's got to answer to something. This is ridiculous.
I do not believe that once, whether it's the Housing Appeals Commission or a state court makes a decision, they make their decision. If there's impacts from that, that adversely affects private property, then there may be a case that a private property owner can bring against the developer for nuisance or damage to their property, et cetera. But there's never recourse against the judge.
Okay, now my other question, how long does 40B, because everything's 40B, and it gives all these stipulations, okay, to our community. How long does 40B last? Like when there's 40B housing, how long do they have to keep it 40B? Is there a time limit on it?
We are at 7.8%, I believe, right now of affordable housing. Once we attain 10%, then developers can no longer utilize 40B against our community.
Okay, so like these other communities, I mean like Acushnet, Westport, all them, like, they don't deal with this.
Some
Why?
of them are more than 10%, others are not. It's just that
There's some that are under that
There are
are
some
in the
that are others.
surrounding area.
The developers have decided to utilize these parcels. They make the determination if they're going to utilize 40B.
And then how long, though, does that housing have to stay affordable housing in these projects?
In this case, we're going to make it in perpetuity.
Forever.
That's one of the conditions, that's one of the
Well,
conditions we're going to put on
and that's what
this.
we should do from now on in this town, because then this baloney would stop. We would make our quota.
Ma'am, I've only been here 12 years. There's only been one
Well, I
other.
love you
hold
for
on.
saying that.
There's only been one other 40B project that we've granted, and we require that that also be in perpetuity, 25%. And that's under construction. That hasn't been done yet.
Uh-huh.
And that's on Route
But
6.
that's what we need to look into. We need to put that stipulation in from now on, so that we
Well,
can
we
make our
have.
quota.
We have, the last one we did, this is the second one that I've been involved in. It'll be on this one as well.
I'm not against affordable housing, believe me. I'm just against them using it to get all these things passed through, and then us as the town people, our water bills, our taxes, the schools, everything, our police department, I mean, the fire department, everything is maxed out, and they could care less, and I'm tired of it. And I was a police officer for 38 and a half years in this town. So to be honest with you, the traffic study is baloney, and that is gonna be a nightmare. Gonna be a nightmare. There's been so many deaths on that road, and I take every death very, very seriously, because I investigated some of them. And I'm gonna tell you something right now, it's no joke. When you lose a family member to crazy driving, and I'll tell you right now, coming out of 8 Country Club Boulevard, it's a nightmare, unless it's at night, you can see headlights coming. Because I don't know if they think it's a racetrack when they leave that stop sign there at the bottom of Allen Street. They are flying around that curve, and you've got a house there that they've already taken care of at one time, but it's growing again. It's got some arborvitaes that blocks your view, and you can't see cars coming in the daylight. Very, very, very dangerous. There's gonna be so many accidents, and we're gonna lose more innocent people to that. That road's so narrow. we've just got too much on that road. There's too much on that road to have this much traffic added to it. I'm sorry, but I just had to say my piece.
Thank you.
Thank you.
But I was starting from the left, working my way over to the right. And then we'll go back.
Fred Dabney, 82 Fairway Drive. To follow up on Mr. Almey's comments, you have 3 40B housing applications before you, I believe. And given the extraordinary amount of water that is going to be required for this application alone, is going to cost the town an enormous amount of money. But when you combine it with the others, I do not see why that does not constitute a tremendous unfair balance for the town, a tremendous burden for the town that it doesn't have the resources to afford. And that's just for water. The sewage component is equally at close to capacity, and we have no idea what the other developments are going to require. So I don't quite understand why you don't have the grounds already to reject this because of those additional requirements. Secondly, they've proposed putting in those street trees, landscaping. How long do they have a maintenance requirement for those trees? Is that all automatically irrigated? Is there any question that that's part of their proposal?
I don't know whether or not there's an irrigation plan, sir, but if water's a concern, we can state that they're not going to irrigate that particular area. We could put that as a restriction. But then we're left with burnt and brown areas throughout this entire subdivision. If they develop it and make it asphalt, then it doesn't have any impervious surface. So it's
But
a
you're costing
situation
the
where
town with all of the excessive water usage that's being required because we have to keep buying expensive water from New Bedford.
Sir, we're going to have more students in schools, and those are concerns that we can't utilize as a means to deny this.
But I thought we heard that you could deny it if it constituted an unfair burden on the town.
Can you explain that to this gentleman?
Yeah. So the balancing, as the chair has mentioned, is local concerns versus the need for affordable housing. And the issue that's come up, and it's been debated in every town that's facing 40Bs since 40B came in the 1970s, is the impact, the financial impacts on the town, whether it's the schools, whether it's, as you're saying, water and sewer. And where, and this hasn't just been that Housing Appeals Committee, these questions have gone all the way up to the Supreme Judicial Court, which is the highest court in Massachusetts. And where it's come down is that even though these projects are typically much larger than what would otherwise ever be built under zoning, they can't be treated differently from other projects that aren't 40B projects. And they can't be held responsible for existing conditions or existing deficiencies in the town system. So the school's we don't have enough classrooms, the classroom size is too big, or the water is too expensive from New Bedford. And so if the town is approving smaller projects, you approve a house gets an A&R lot with one house here, 2 houses there, or a commercial store gets built, or, fast food store gets approved. Everything else is getting approved. No one's saying, well, they're going to use water and we have to get it from New Bedford, but you're saying it for the 40Bs. And that's what the law doesn't allow. It doesn't allow the 40Bs to be treated differently, even though they're much larger with larger impacts, than anything else. And so, unfortunately, eventually, with the wastewater treatment plant, if it hits its capacity and DEP says that's it, no more connections, well, it's not going to matter whether it's this 40B or a project that the zoning board approved at its last hearing or the planning board. No one's going to get a connection. So that's the risk. Like these projects can get permitted, but if the wastewater treatment plant hits its limit, and I'm not the expert on this, obviously. DPW knows better than I about how it will work, but at a certain point, no one's going to get a connection. And it will be across the board, and it won't matter what type of project it is. So, and unfortunately, for the concerns that you're raising, they're not real, they are real concerns. They're legitimate concerns. But 40B does not allow the town to impose those concerns on a 40B project differently than it does on any other project in the town.
So basically, we can't control the cost of our tax rate in town if we're forced to put in projects that are going to cost us more money than we have, and we can't do anything about it.
I mean, so there's a lot I can respond to this, but I want to kind of stick within the context of the hearing. I mean, the state, a couple of years ago, passed a huge bond bill with all these funding for grants, for communities, for infrastructure. It's all things that your town officials are looking at to defray the cost of these infrastructure issues that you're having, et cetera. But, right now, that's how the state's proposing, is the towns are going to keep letting all this building happening, and then they can come to the state and ask for some money to help them pay for the costs of a wastewater treatment plant or whatever it is. But, and like I said, I don't want to get too much in the weeds, but that's how, all I can speak to is how the state is adopting the laws today, and that's happening at the State House. And it's not happening in Dartmouth. It's not under the control of Dartmouth
I
Town Hall.
understand that. I
Yeah.
wish we could amend 40B, but thank you for your time.
All right, I think there was somebody down this way. Sir, I'm going to work my way back over to the right. Come on over.
Eric Duat, 940 Tucker Road. Just had a question about, is there going to be restrictions on construction time and days? Because my wife works nights and
There
stuff
will
like
be, sir.
that. Yeah, okay,
There
so
will
like
be.
no
There-
Sundays and like certain hours and stuff like that? Because I know with building homes, I'm in construction.
That's a standard condition that we're going to have.
Okay.
And that has
Well,
to
not
do-
everybody follows it though, that's the
Yeah.
thing, yeah.
Next week, we're going to be going over conditions. Not next week, I think it's the 13th. We're going to still talk to the petitioner about that, extending this to the 13th. But we'll have a list of conditions, and one of the conditions will be, obviously, the days of the week, which will be Monday through Friday, how early in the morning the operation can start, and when it ends in the afternoon.
Okay,
Okay?
thank you.
Thank you. All right. Okay, next, I'll work my way over to the right.
Hi, Dennis Manor, 54 Hyacinth Drive. My question is, the easement, if it goes to court, what kind of an effect does that have on the board?
You say the easement, which easement you talking about? The one to access Fairway Drive?
The access to Fairway
So,
Drive, yeah. If it goes to court, does
If
that?
it goes to court, it'll be the private property owners who own or have a right to Fairway Drive. They would probably bring an action against the developer, and however that turns out is going to be determinative of what happens with that particular area. And if it's denied, then they're going to have to come back before us, I would suspect. They're going to have to come back before us with a new plan showing another form of egress.
So you can't do anything until it comes out of the court?
Well, I don't even know if it's going to go to court.
Neither
So
do
you're
I,
making an
but
assumption that it's going to go to
push that
court.
it does, but if it does,
If it
I want to
does-
know what kind of an impact that it has on the board. Do you still make a decision? Do you wait for the outcome of the courts?
We have to wait, if the court makes a decision and the court denies them access to Fairway Drive, then they have to come back
That's-
before us.
You're not really listening. If it takes a year, do you sit on that for a year if it drags through the courts?
We've granted, if we grant the permit,
Uh-huh.
then I would believe if there's going to be an action that's going to be brought by the neighbors, then it would go through the court system.
Right, so what happens when it's in court? You've already granted something. Does it cease until you get something back from the court saying one way or the other?
Well, it depends on whether or not that's what the petitioners asked for. If the neighbors asked for there to be an injunction to be placed during the period of time in which the court's determining it, then maybe that's what would happen.
It's not a question we should.
But
be
no, it's
dealing
really
with.
not, but, look.
It's not a question for the board?
Correct.
How about to the
It's
attorney?
not a question for her either.
I was trying to
There's a
address it,
case.
but you know something, it's really not something we should answer.
Okay, thank you.
Moving, someone over here had raised their hand.
The 82 Fairway Drive. I know earlier this evening, I can't remember what the issue was that came up, but you said if you granted approval and it was not about the emergency egress, and then something was not approved before you approve it, what is the protection for those people? And I think that's what people are trying to get at. What is our protection as abutters? If you approve this, yes, we got a lawyer, we go ahead. But if they deny, on our part, they deny us, and they still get it, that's the end of it. But if we deny it and they've already started construction, where does that leave it?
Well, you're going to have to hire a lawyer at that point. But again, I think this stems from the similar question to what he has.
But
He's
whose
for-
responsibility is that point if they've begun construction and they aren't going to have egress?
Well, I don't, well, one of the conditions we're going to require is that they're going to have egress to the premises that is approved. We have some language that we put together as one of the conditions.
Okay, so that has to be approved basically before they can start constructing, is what you're
That's
saying. Okay, that was my question for that. I have a question, which I'm going to ask you, but it is actually of Mr. McFarland, because Mr. Farland, we were not able to ask questions at the meeting where he showed the west side of the property where the drainage was all going to end up. And at that meeting, I think there was a question about how to access any of that, if there was ever a problem with it. And we never saw that or got an answer to that question, and I would like to bring that up again because I think that drainage, the access, I don't believe could be from Country Club Road.
No.
And I don't believe-
Actually, Mr. Barber spoke about that. There have been communications between himself and the engineer, Mr. Farland, about creating an easement from this particular location, this lot, onto the easement area that's on the western side of the property. That's not on the plan as of yet. That's something that they're going to work towards.
But it would have to be off of their property. They would not be using any of
Be off of their
nothing off
property.
Fairway Drive
With it, no.
or abutting the Fairway Drive behind those properties.
It's going to be from their property accessing the easement area. Is that your understanding, Mr. Barber? Yes.
Thank you. Thank you. My third point is just that the problem from the very beginning, from my point of view on this, whether it goes or it doesn't go, is the density. We could have 50 houses in there that were all affordable housing, and this would not be happening. This would not be happening. It's greed and density.
Thank you. All right. Is there anyone else on this side who would like to come forward?
Karen Everett, 66 Fairway Drive. Been a resident of Dartmouth for 50 years, lived off Fairway Drive for 27 years, and I have a lot of interest in what's going on with the 40B project. One of the questions that came up tonight was the project they're presenting, is it going to be in the form of a town-approved subdivision where there'll eventually be approved roads, sidewalks, lighting, and so forth?
We're actually doing all that now. Under 40B, this board serves as not only the zoning board, but we serve as the planning board as well. And all of that is coming before us now, and we're approving that with certain conditions. So the width of the roadway is something that we're approving or we're allowing a waiver to. We're also doing the sidewalks with Cape Cod berm. Those are the things that we're approving, obviously with certain conditions.
I want to thank the board for listening to your neighbors, and I hope that you can make the right decision for the town.
Thank you. Is there anyone else on this side that would like to speak? I'm going to go back over to the left again.
Should we hear from the applicant?
All right, wait, oh, he's getting up.
Attorney Murphy and I discussed, we will agree to, I assume that if we continue to the next session, that is going to be dominated by just us talking about the decision. So I've spoken with Christian and with our client. We're willing to agree to an extension and a continuance to
The
to that
13th
date.
of April?
To the 13th of April
Is that
for
a
the
Is that a
purposes
Monday?
of working.
Yeah, Ms. Vieira has a form. If she can fill in the date and sign it tonight, that would be great.
That's fine.
Now, do we know, but before we do that, obviously, they're going to want a copy of whatever that is. I'm going to want a copy of it, obviously, and this is going to be voluminous. It's not something I can just read
No.
in a night and be able to understand what it is. And I don't want to put a lot of pressure on you. I don't want to put a lot of pressure on you.
It's my job.
All right. So, the Monday, next Monday is the 30th, the Monday after that is the 6th, and the Monday after that is the 3rd. So that's roughly 3 weeks to the 13th.
So, Mr. Chair, so with the extension, then I have the ability to kind of make sure that there can be some conversations. There may be some questions that, say, Mr. Farland, Mr. Barber, Mr. Diosa need to talk about, et cetera, those types of things happening for clarification. So if I was able to get it to everyone by, at the latest, April 6th, which would be a full week, would that be acceptable to the board? Okay, so that will be my last date. If there's any way I could get it out, say even the Friday before, and give the board another weekend, I will do that.
I know, we did, but they're still, now you gotta write them and make sure the verbiage is good and all that. But we've got a precursor of what these things are going to be, right? But they're just gonna be a lot more elaborate in the sense of what's gonna be.
Yeah, we talked about it at the break, too. I mean, we probably both have our styles of drafting these things, but it's not like anyone's reinventing the wheel. We expect it to be a voluminous decision, and between myself on the legal side and Christian and the rest of the team on the technical side, I'm sure we'll get a good set of comments back and be prepared to hammer out any differences that we have. I mean, I'm confident that we can.
And I would say, Mr. Chair, just so, again, to not reinvent the wheel, like you said, I might have a little different stylistic, but there's a,
Yeah, it's gonna be at the high school.
there's a,
So I wanna make sure I let
no,
everybody
there's
know.
there's the decision you issued for the preserve that has a number of the standard, conditions, right, that are not specific to the site, which, for consistency, I might tweak them a little bit
Yeah.
as my style, but I think that if you look at that, you'll see that a lot of the standard, non-project specific
If you
conditions.
could send that to me, that would be great.
It's on the website.
Oh, it is?
If you
Okay.
search Dartmouth, Mass,
Okay,
the
so it's on the
preserve,
zoning,
the
sure.
40B decision is on their website.
I'll take a look at it.
So, I mean, to give you a preview, those are the types of kind of standard conditions. I'll probably try to use those for
Yeah, I mean,
consistency.
and the boilerplate isn't going to be the
Yeah.
issue, and I'm sure there's
No.
a huge amount of boilerplate. It'll be some of more of the technical things, but we'll work it out.
All right. So for the audience, we're going to be taking a vote to continue this matter until April 13th. At the next hearing, it's going to be at the town, it's going to be at the high school. It's going to be at Dartmouth High School in the auditorium. It'll be at the Dartmouth High School auditorium. Our goal then is to be going over all the conditions that we're putting on the project, and the reason for the conditions is to lessen the impact that it will have in the community in general, to the immediate abutters, to wastewater, things of that nature. So we'll be discussing those, and we'll be going over them basically line by line. I expect there are probably going to be a couple hundred of them that we're going to have to go over and discuss. Many of them are boilerplate. We'll probably go over those rather quickly. Obviously, it's still a public meeting, so there'll still be possibly some limited public comment on any of the concerns about the conditions, but obviously, that's something that we'll take on a case-by-case basis, so to speak, on whoever has concerns. I guess there's still a gentleman that would like to speak, and I'll give him an opportunity. But if you could just step back just for 1 minute.
100%.
He's asked, come forward.
This is pretty simple. Will the conditions be available to the public before the meeting?
It's up to the board. If you want, Michelle can post them to the public site.
The only thing is I just want them to be labeled in very bold print,
Yes,
draft.
yes,
That's draft, right?
Yes.
And for discussion purposes only.
Yep.
So that way there'll be, every page should have that on it, okay? Then we'll have it posted probably on the 6th as well, okay? You're very welcome. All right, so at this time, I guess I'll entertain. Oh,
Want to sign this one?
oh, yeah, is there something for me to sign? Yeah, I'll sign it right after. But he's already indicated it on his representation. I'll entertain a vote, gentlemen.
I make a motion that we continue comprehensive permit ZCMP 25-1 to April 13th at the 6 o'clock at the Dartmouth High School auditorium.
I second that motion.
All in favor?
Aye.
Aye.
Aye, the ayes have it. All right, gentlemen, is there any other business that we need to discuss? Any past business? Any new business? No. I'll entertain a motion to adjourn.
Motion to adjourn.
I second that motion.
All in favor?
Aye.
Aye, the ayes have it.